Bom dia, boa tarde, boa noite, boa madrugada para os corredores. Pessoal, nós chegamos no episódio 250. É isso aí, pessoal. O Onze está aí caminhando para completar 6 anos de vida e a gente está fechando o episódio número 250. São mais de 350 horas de conteúdo produzido. E como me perturbaram muito, eu antecipei o episódio com o ministro Luiz Roberto Barroso. E para o episódio 250 eu não podia fazer feio, então eu trouxe uma juíza da Corte Constitucional da Colômbia, ministra, magistrada, justice, do jeito que você quiser chamar. Lá na Colômbia eles chamam de magistrada, eu não sei a pronúncia em espanhol, porque meu espanhol é péssimo. Nathalia Ángel Cabo, que também é professora. A gente esteve com ela aqui conversando sobre uma decisão muito importante da Suprema Corte, da Corte Constitucional da Colômbia, porque eles também têm uma Suprema Corte, sobre justiça climática e constitution, né, adjudicação constitucional. Então a gente conversou sobre um problema de deslocamento forçado de pessoas em decorrência de fenômenos extremos decorrentes do aquecimento global e como a Corte Constitucional da Colômbia tentou criar um framework para que a decisão não só fosse implementada na prática, mas para que o legislativo, com as informações fornecidas pela Corte, tivesse os instrumentos necessários para dar continuidade ao enfrentamento desse problema. A conversa ficou muito bacana, vocês já sabem, tá disponível aqui no YouTube com legenda e o áudio original em todas as plataformas de áudio. Se você escuta em inglês, você vai conseguir escutar no Spotify, no Apple Podcasts, etc. Se você prefere escutar com legenda, é só acessar aqui pelo YouTube. Lógico, não esquece de deixar o joinha, se inscrever no nosso canal, dar 5 estrelas lá no Spotify, no Apple Podcasts, faz a nossa avaliação, ajuda sempre a gente a alcançar mais gente. E, obviamente, se o Onze faz parte da sua vida, como eu acredito que faça, porque eu não acho que você não está aqui à toa, se o Onze te ajuda a crescer intelectualmente, e se a minha voz e a dos nossos convidados aqui continuam martelando no seu ouvido durante todas as semanas, não deixa de dar uma conferida no nosso Apoia-se, está na descrição do episódio. É, Você pode escolher qualquer um plano que tem lá, você vai acessar com antecedência todos os episódios do Onze. Você tem acesso a esses episódios, você tem acesso a recebimento de livros da nossa curadoria. Você pode também fazer um Pix recorrente para a gente, a chave aqui está na descrição do episódio. E é só, quando você fizer esse Pix recorrente, não esquece de mandar uma mensagem com o seu contato para eu poder adicionar você ao nosso grupo lá no Telegram, certo? E, obviamente, não posso deixar de mencionar meus dois patrocinadores queridos, minha querida Contracorrente, editora do meu coração, que tem lá seu clube do livro no www.quebracorrente.com.br e que também fornece para a gente um cupom maravilhoso que dá 25% de desconto em todo o site da editora e ainda reverte para a gente em comissão. Então, aqui na descrição do episódio você vai ver o cupom direitinho, como é que ele está escrito, 11 Supremos, por extenso, 25 no número. E aí também temos o meu querido Ouse Saber do Felipe Augusto. O Felipe lá comanda um dos melhores cursos preparatórios para concurso no país. O Ouse já ajudou mais de 5 mil pessoas a serem aprovadas nas grandes carreiras da magistratura, Ministério Público, defensorias, procuradorias. E eu tenho certeza que o Ouse tem materiais de excelência que vão ajudar você a encurtar o seu caminho até a aprovação. E é isso, pessoal. Eu espero que vocês gostem do episódio de hoje. Meu nome é Davi Sobreira. Esse é o Onze Supremos, um produto do Ulisses Centro de Estudos Constitucionais. Everyone, I have the honor here to interview Professor and Justice, and in Spanish, my Spanish is not so good, Magistrada Nathalia Ángel Cabo from the Colombian Constitutional Court. And today we're going to talk about the acting of the Constitutional Court in Colombia, as a matter of fact, in the theme of climate change and the problem of forced displacement. So, for us to begin, Professor, how does the Constitutional Court distinguish the idea of internal forced displacement from cross-border migration? And Why does that line matter for public policy design in Colombia?
So I think the term itself distinguishes the phenomena. So basically, when you're talking about internal force displacement, you're talking about the movement of people or the displacement of people within the state. Whereas the cross border means that you are crossing the the borders of one state. We have dealt for many, many years with cases concerning for internal force displacement in Colombia. There's a very famous decision, I think is one of the most well-known decisions of the Colombian court, which is T025 of 2004 that deals with internal force displacement. And we've been monitoring that case for many, many years. So in the process of the monitoring of this decision, the court has also, let's say, laid the foundations for a comprehensive state response that is not limited to internal force displacement, but also to cross border displacement. So the court has been very much concerned about those two phenomena, although most of the focus has been on displacement that occurs within the borders of the state of Colombia. And so you see that our laws, the first law was originally a law of the 97 about the protection of forced displacement. That was a law 380 and 87 of 1997, and it only focused on internal displacement and the response to internal displacement. But our case law start to recognize also the phenomena of cross-border displacement, particularly in areas where there's a lot of violence. So, for example, there's a huge problem of forced displacement in the north part of the country that is in the border with Venezuela. And so you will see a lot of phenomena of cross-border displacement there. And so our court has been signaling messages even to the legislature that our laws and our response to displacement has also to encompass or to address issues of cross-border. But mainly our focus has been on internal force displacement. I will only add that recently there's a law in Colombia enacted in 2024 that basically expanded the protection of including a kind of protection for victims abroad. And that will address issues of cross-border, which is very important due to the fact that usually cross-border displacement was, or the response was refugee law. But refugee law is very, very limited to the kind of phenomena and the mobility of people that were happening in the country. So refugee law is limited to specific grounds for granting refugee status, for example, when it happens because of race, religious, nationality, membership, or other causes. But you need to prove direct relation. Our jurisprudence instead is more broad and allows for cross-border displacement that is not only limited to what international refugee law addresses. So I think this new law, which is a law of 2024, would be important because it's basically signaling that there could be some protections from people in displacement that just not within the state, but also cross-border forced displacement. And this is also very important for the topic that we are going to talk about, which is the topic of displacement due to climate change, and not only of violence and armed conflict. But what I mean is, it's a different phenomenon. One is occurs within the borders of the state, and the other means that you are basically leaving the state to go to another country. But it's in our country, the conflict makes those peoples even sometimes to be forced displaced within the country, and sometimes to go to other countries. And that specifically is very common in Colombia, in the northern part of the state, with the border with Venezuela, which we are seeing very easily this idea of internal forced displacement, but also of cross-border forced displacement.
Perfect. Professor, trying to understand a bit of the social environment, understanding the Colombia from a social environment perspective. What are the structural factors that have produced this large displaced population in Colombia, and how does climate change compound to this dynamics?
So it's important to bring this issue of climate change now into the discussion, because what I've been telling you is that in Colombia, we've been dealing with issues of forced displacement for many, many decades. And most of the displaced, at least the ones that we recognize, are people in forced displacement due to violence and armed conflict. And so, as I mentioned, we have a law addressing the issues of displacement since 1997, but basically is recognized people in forced displacement that were displaced even prior to the 90s because of the armed conflict and forced displacement. What is interesting now is that we are also recognizing that persons in internal forced displacement in Colombia are not only people that were forced to displace because of violence and armed conflict, but also due to what we call environmental factors that include disasters and issues associated with climate change. And that has been very, very important since 2004, with a decision that I am proud to be the rapporteur of that decision, which is called 123. We use numbers, so it's T123 of 2024. So basically, that decision explicitly says that the Colombian state has to recognize that people in forced displacement in Colombia are not only displaced because of the violence and armed conflict, but also because of other causes. And one key cause nowadays that we have to address and basically have a public policy that address that issue is displacement because of issues associated with disasters and climate change and degradation also of the environment.
Taking a link in just the last part of what you last said, you was a rapporteur from the proceeding, I think is T123 from 2024.
I really like the number, as a matter of fact, because so our decisions are just by numbers. But the fact that this case was allocated the number 123 was random is perfect, because 123 is the emergency number in Colombia. So basically, I think it's symbolic that it says this is an emergency, which actually is not only in Colombia but worldwide. So it's important. The number is symbolic, very symbolic.
Very curious. So, as the rapporteur, what legal and institutional gaps convinced the court that the people displaced by this slow onset or the sudden onset of environmental harms deserve the same constitutional status as conflict-induced displaced population?
We will have to say that the decision is not necessarily saying that it has to have the same constitutional status. And so let me explain a little bit about the case, how cases reach the court, and basically because when when you understand the facts of the case, you understand what we did in 1, 2, 3, and I think it's important to say that even, and then we can talk about the Inter-American Court opinion, but 1, 2, 3 is a really pioneer decision addressing issues of forced displacement and climate change. Is a very comprehensive one. I was very proud to hear from the UN rapporteur on displacement that the 1, 2, 3 decision was very influential, or has been very influential, even internationally. So I'm really proud of having being the rapporteur for this decision. So basically, the facts of the case could be just simple. There was 2 peasants, elderly, so they were, I think, more than 60 something years old, and they derive their subsistence from their land, so they had crops and they had chickens, and that was the way they basically made a living. But they were living close to the Bojava River, one river in Colombia, and there were 2 floods in that river that forced them to go to the municipality, to the center of the municipality, to the urban area, let's say, twice. And basically the municipality didn't provide services and didn't provide it with a place to stay, or didn't provide it with attention due to the fact that they had to move from their land because of the flooding. The floodings are important, and because that is how we make the link with climate change, is that in Colombia, and I think in Brazil as well, we have recurrently 2 phenomena that are the Niña phenomenon and the Niño phenomenon. And there's the Niña phenomenon, there's a lot of rain, and that has been going on for many, many years. It's a recurrent phenomenon. But what we are seeing nowadays is that the Niña phenomenon and the Niño phenomenon are stronger due to the fact of climate change. So these are not current common floatings, are just more strong than what they have been usually happening for the past decades. In the past decades, I apologize for my English, but in the past decades. So what happened is that these persons went to the big unity of victims. And so the unity of victims is a unity that provides services for persons in forced displacement. So in Colombia, as I mentioned, we have been dealing with forced displacement for many decades, and there has been a lot of, let's say, institutionality around addressing the needs of people in forced displacement due to violence and armed conflict. And that happened, as a matter of fact, after decision T025 of 2004. So the unity of victims basically providing service for persons in forced displacement gave the answer to this elderly person saying, well, sorry, our mandate is limited to persons displaced by violence and armed conflict. So we cannot provide any services to you within the victims law because this is only limited to persons displaced by conflict, by armed conflict. And so this person said they put a tutela action, and so a tutela action is a writ for the protection of fundamental rights, which is a very important action in Colombia. It was basically created in the Constitution of 1991, and it means that anyone who thinks that a fundamental right has been violated can go to any judge in the country. At the end, all of the tutela actions are sent to the Constitutional Court. And just so that people understand how important this tutela action and how people resort to those tutela actions, we receive at the court around 80,000 cases a month. a month, not a year. And so, but we basically choose out of those 80,000, only 40 for the court to make a judgment. That doesn't mean that the other rest are not decided. They are decided by trial judges, but the case only picks and choose 40 just to decide. And one of the cases that picked was this one, because definitely the court saw in this one not only that there were two people, very vulnerable people without assistance, but that this was a case that the court needed to address and tackle. So basically, in this case, these plaintiffs went to the unity of victims, as I said, and they said, well, sorry, no, you are not persons in forced displacement according to our mandate. And so what the court did was saying, no. So this person said, no, we are persons in forced displacement. And they basically resort to the Deng principles. The Deng principles have a definition of forced displacement that includes not only violence and armed conflict, but also disasters and factors associated to issues. Said that disasters and factors associated to acts of the people can also be factors of forced displacement. So it's a bigger, a broader a definition of forced displacement that includes different causes. And we have used previously the Deng principles when addressing issues of forced displacement, of internal forced displacement in Colombia. So we recognize those principles as ones that are very important in order to address how the state should approach persons in forced displacement. So the tutela, when we had it, the first thing that we had to address was whether these people were people in forced displacements or not. So I think one of the things that the decision does that is very important is saying people that has to move from their place of living, not voluntarily, but forced to their circumstances. And those circumstances are associated to environmental factors, including disasters or including factors associated to climate change. Those are also people in forced displacement. So the cause, it's not as, so forced displacement can be caused by many issues, not only violence. And that was very important, that recognition, because it's saying these are very vulnerable people that require a response from the state, and these are persons in forced displacement. But then we started looking that it was true that the unity of victims cannot provide services for these people, because basically it's true, their mandate is limited only to provide services for victims of violence and armed conflict. So this decision is interesting because what we started to do was analyzing international treaties, those that Colombia have ratified. We analyzed the laws that we currently have, and we basically realized that there's a deficit for protection of people in forced displacement due to climate change in Colombia. So that we said, yes, these are persons in forced displacement, but the current laws and even the current international framework that has been ratified by Colombia, it's limited to address this issue. So I think that is one aspect that must be highlighted about this decision, is the recognition and also the understanding that there's a deficit of protection. There's a second element in this case, which I found it was interesting. We said, well, if there's a deficit of protection, this deficit of protection must be resolved, and must be resolved by Congress by enacting a public policy that addresses this issue. So we really did this in a kind of in a way to do the homework for the research homework for the Congress. So if you see that decision is a long one, but it tries to basically bring into the judgment everything that there's at the time was out there about forced displacement and climate change. So you will see a lot of international instruments. You will see basically the what rapporteurs have said about the issue, the UN rapporteurs. You would see a lot of soft law, but trying to basically doing the research homework for legislature in order to address this issue more broadly. So that's one part of the decision. You will see it is about what is out there, what has been said internationally, what has been said nationally, and how we can address this. I think we did it well. I think I'm an academic, and I sometimes think that these decisions have power also by educating the people about issues, and also by putting the topic into the agenda. And I think that judgment has, or at least served those two purposes. But then deciding in the particular case, so basically was easy, was saying these persons were persons in forced displacement. There's a deficit of protection, but a deficit of protection doesn't mean that they are not entitled to protection. So there's an obligation to protect them. And in the case of these two persons, we gave specific individual orders to the municipality to provide for assistance for these two people. But the judgment is more ambitious and basically said that the government and Congress, it needs to enact a public policy addressing the issue of displacement and climate change.
Professor, if I may, there are 2 points on the fundamentals of the T123 decision that I think we must focus on. The first one is, how did the decision, the T123 decision, dialogue with, because you explained that it's like the court did the constitutional dialogues at its finest. It brought everything it could to the decision.
Everything, well, at least what we found.
So the Congress got the homework and could do its part with more ease. So how did first the decision explained the difference and the necessity of protection between the forced displacement for decoring from climate change and decoring from violence, and as well, how did the soft law and the international law that you mentioned, that it is part of the decision, international agreements like the Paris Agreement, the UN principles for forced displacement, how does this provisions dialogued or were in tension with the Colombian's 1991 constitution?
Okay, so I'll give you two answers differently. So I think I will start with how we incorporated international law and national law within our discussion of the case. So as I mentioned, what we were trying to do at the beginning is what is out there that can be useful for us to address this case. So we look both at the guiding principles on internal displacement that, as I mentioned, have been very influential also in our previous jurisprudence concerning forced displacement, but we look at other international sources. One of the things that is important to know is that Colombia has long embraced international law through what we call the bloque de constitucionalidad, which is the constitutional block. So basically, the Constitution of 1991 allow us to use international law within in our decisions. Some are mandatory, have the same level as the Constitution, which is what we call the strict bloque de constitucionalidad, the strict constitutional block. And basically, the Constitution says that international treaties human rights international treaties ratified by Colombia are part of the strict block.
We have in Brazil something very close to it.
Something very similar as that.
When we ratify a human rights agreement with the same procedure of constitutional amendment, it is like part of a constitution.
But we also have something that we call the bloque de constitucionalidad en sentido lato, which is, en sentido lato, is not, it will not be in the same level, but these are international treaties, even, for example, the guiding principles that have not been, they're principles, they're sometimes they're soft law, but that we can use as basically providing arguments and providing a framework for decision. But that we will have to basically relate them with the Constitution. So let me just, so they will provide you interpretative frameworks. And so that's how we use it. So international law, both in treaties ratified by Colombia, but also soft law is very much used in the Colombian jurisprudence. So we use that, and we basically look at many things that what was out there. So the Paris Agreement, for example, we ratify the Paris Agreement, and definitely Colombia has some obligations under the Paris Agreement. But in this case of the 1, 2, 3, for example, we point out that there was not in the Paris Agreement a very clear response to persons in forced displacement, of internal forced displacement due to climate change. So with the Paris Agreement alone, the response, it's still not enough. And we also look at laws concerning even our international commitments due to forced displacement. And we also realized that the issue of climate change was not necessarily addressed comprehensively. We look at our laws, and definitely, as I was mentioning, that was not a topic in our laws concerning forced displacement. So both we look at issues, we look at international treaties concerning climate change and forced displacement, and we also look at internal laws concerning those topics. And what we found is that basically, well, there's needed, I think, both in the international arena and the national arena to address more fully and more comprehensive the issue of mobility and climate change. And I think this is starting now, and we've seen it more with, for example, the Inter-American Court recent opinion on climate change that has a chapter on forced displacement, which and cite our decision, which I'm really honored that it was useful. But that's what we did. So that's one thing about the basically the framework, the normative framework. But the other thing, and you were asking about the difference between forced displacement and when it's caused by violence and armed conflict and due to climate change. We thought a lot in the decision whether it was the same phenomenon, it was not the same phenomenon, and mainly was whether the response should be the same. Because we could have said in our judgment, for example, well, include in the framework or in the public policy, in the current public policy addressing internal forced displacement, include also people in forced displacement and climate change. That would have been a mistake, in my opinion, for two reasons. The first one is that we already have a lot of challenges fulfilling the promises that the state made with people in forced displacement and armed conflict. So the law of victims has been a very important law, but still there's a lot of challenges to provide, for example, for reparation and also for assistance for this. And this has gone its own particular track. The second reason, so we said we have to think this over. You cannot just simply add people to the commitments of that law, of the law of victims, because that would basically, what you will do that is just provide for disillusionment, because the challenges to comply with the law has been very big. So you really need to discuss this. Congress needs to discuss what we are able to provide. We can promise. It's not about promise. It's just seriously what we can basically fulfill. So we were cautious on that end. But the second thing that I think it would be interesting to discuss this matter with caution, because we saw, at least in what we study, differences between the way we have addressed displacement due to armed conflict and displacement due to environmental factors. One of the things, for example, that is interesting is that how can you basically, so in order to provide services for persons in forced displacement, you will have to determine whether these people are persons in forced displacements or not. So usually, for example, within the law of victims, what the state does is to see if there was a fact, actual fact that allow you to say, well, that in that municipality, for example, the guerrilla came and basically forced people to move, or there was an issue regarding the armed conflict that was kind of, if you study, it would be easy to find the cause associated to the armed conflict. Instead, in climate change mobility and climate change displacement, sometimes the cause is not that easy to find with, let's say, with a particular act. So sometimes, for example, this is, and that's why some rapporteurs have addressed this, that what make people or what force people to move from their land is not a single issue that you can identify easily, but rather issues that happened over time that sometimes are invisible. So the degradation of the land. So your crops are not, you cannot have food anymore. So, but they are gradually, they are slow. I always use the metaphor of a title of a book which I really like, that is called Slow Violence. We also use it in the 123 2004. There's a book which I like a lot that is called Slow Violence, Environmental of the Poor. But it's precisely addressing this sometimes the issues that have to do with the environment, with climate change, are invisible, are happening gradually. And so the costs that make people mobilize is not as visible as sometimes happens with issues due to climate, to violence and forced displays, where it's much more easier sometimes to basically identify what was the cause that made people mobilize. So that was one of the things that we show. But we also show another thing is that those two displacement, or those two, let's say, categories of displacement, if we're going to call it them in a way, are not that different. Because many times, people that have to mobilize or to displace due to violence and armed conflict, they basically arrive to ecosystems that are very weak. So places that will be very much affected by floods, very much affected by issues associated to climate change. So it is not uncommon that you will have within one family that they have been forced to displace twice, once by violence and the other by climate change. So those are the kinds of issues that we put it out there, but saying is for the legislature. So these are the things that we're seeing, but I don't think it's for the court to address them all, because this means that a state, what we say is the state has obligations, and that was similar to what we say in T0 25 of 2004, is that the state has obligations before displacement, prevention. It has obligation during displacement and after displacement. And those obligations, well, require a lot of things. What we can provide, they require, where are we going to find the resources to provide for those, to guarantee those obligations? Definitely, I think you are in Brazil, the discussion about socioeconomic rights has always been, the budgetary part of that has always been a very big discussion. So we definitely said you have obligations that you have to fulfill, but it's not for us to design the public policies, for the Congress to do it.
Perfect. Professor, grabbing a continuation on this last part of what you just said, when courts deal with budgets from other political branches, this is sometimes raises questions of legitimacy, and sometimes lead the political branches to a brink of a crisis. This is very common in Brazil in the last few years, when the Supreme Federal Tribunal has tried to bring more transparency to the budget that has been overly appropriated by the legislative branch. In Colombia, Colombia Constitutional Court is very famous for being bold, for example, in developing the unconstitutional state of affairs doctrine that has been exported for several countries, including Brazil, have used, I think, 2 or 3 times here. So I ask you, in the 1, 2, 3, I believe there was an imposition for the executive to make budget expenses to deal with this displacements problem. How did the political branches have received this decision?
No, so it was not an imposition. So basically, I think, like in Brazil and Colombia, we have discussed the issues of socioeconomic rights adjudication for many, many decades, not years, decades. And definitely the discussions of whether courts should be adjudicating socioeconomic rights, the debates have been, I think, similar. Even you have a Brazilian author that says that is harming the poor, but we said no. But there has been a very big discussion for decades on whether courts can adjudicate socioeconomic rights. I don't think that's a debate now in Colombia for many decades. They simply do. So I don't think that's our discussion. But our discussion has always been what's the best way that courts can adjudicate socioeconomic rights. And when we think of the best way, we also think in a concern of implementation, because you cannot have very beautiful judgments if they are not going to be implemented. So we have a concern of that, but also basically the, let's say, counter-majoritarian difficulty claim that has always been there in the discussions of socioeconomic rights. So we have had this too. And I think in Colombia, we have a learning curve in this discussion that you can also see reflected in the 1, 2, 3. But I will tell you in a nutshell, kind of the debate about remedies in Colombia. So, for example, the Estado de Cosas inconstitucional Constitucional was basically developed in Colombia, or at least created in Colombia in the 90s. At the end, the first decision was 1997. And one of the big cases, for example, in that time was on prison overcrowded. And basically, in that case, the court basically provide for strong remedies, saying the legislator and the government what it has to do, you have to do it this way or not. And there was a big debate on Colombia of whether the court has all the elements. We are actors of public policy. I think when we deny that, I think is nonsense. If you say you have to do this, you have to provide for this, well, you are in a way influencing public policy. But we don't have all the resources to, and I would not say the technical expertise, which is another critique, but we don't have the resources to provide for a comprehensive public policy. And that was a big discussions in the 19th, also with a topic that I think it relates to Brazil, because Brazil and Colombia, we are the ones that adjudicate health rights the most. In every article, literature that talks about socioeconomic rights, they will put Brazil and Colombia. And there was a big discussions in the 90s about that. It was not about whether we could adjudicate socioeconomic rights, but what was the best way. And the 2000 brought a discussion that the best way was to have, let's say, soft remedies instead of strong remedies when we have these big cases of structural nature. Not all of our cases we have not in all of our cases we have declared an unconstitutional state of affair, but as structural cases such as the 1, 2, 3, basically work in the same fashion. You need to have different agencies that work, try to resolve together a very structural problem, which is affecting a large number of people. And so at the 2000s, we had that discussion, like soft remedies could also be a good solution for the court to adjudicate rights, but providing the legislature to a space to react and find the solutions. So that was 2000. In the 2000, let's say longer, within actually the first time that we provide for soft remedies, saying you, the Congress, have to improve your public policy, but you are the one who are going to come up with a solution, not us. That was the T025 of 2004. So one of the reasons why that case is so important is not only that address the massive problem in Colombia that is forced displacement, but it also was novel at the time of the type of remedies that the court designed to use. And the monitoring phase was the first time that the court has, that we are monitoring. So we are going to say, you, Congress, will come up with a solution, and you, government, will provide solutions. You're the ones who's going to design that, but we're going to monitoring that what you promise, you will fulfill. And so that's what we've been doing for the past 15 years, like monitoring. But that case brings another element which has been really, really important in our learning curve of remedies, is the importance that there was not a dialogue between the court and Congress, or the court and the government, but the importance of bringing social actors, bringing the victims, bringing really a dialogue among different actors, the academia, NGOs, and universities, to provide for ideas. Basically, we're basically in these dialogues and in these public hearings, bringing ideas for the government and the Congress to respond effectively. So basically, the 1, 2, 3 is a very deferential decision, because it is putting the topic there. It is making a diagnosis there. It is reminding the government about its obligation with persons in forced displacement due to climate change and other environmental factors. But it's saying you are the one who has to come with a public policy with how we are going to respond to this phenomenon. So this is a first stage, saying we're gonna, and it's not an imposition. It's called exhortos. I don't know the word in English. It would be just asking the Congress to do this, at least in this first stage. So these are your obligations. You must. We don't order. It was not an order. It was basically. We're calling it exhortos. I don't know if we can have the translation. Is asking.
I think our Brazilian audience will get the idea. Here in Brazil, we got 3 different moments due to what we call a DPF. It's an action to fill gaps in the Constitution when the Constitution has ordered something and this something was not delivered. Actually, it's an inconstitutionality by omission. I'm correct.
Yes. Yeah.
In this case, in the first moment, a few decades ago, the Supreme Court was very deferential. They just said, "Oh, there is a gap, there is an omission, and you legislatives should do something."
Yes.
And the second moment, when they saw that the legislative were not taking act, they said, legislative, we are taking action. We are saying what will be done as to now, but you have the power to make substitute legislation to amend or replace the decision of the court.
Yeah, it would be very similar to what this would be exhortation. So first it will be kind of a call to Congress to basically address the issue. And we did it like that because definitely this is a novel issue, not only in Colombia, but elsewhere. But as I mentioned, because we were also concerned about not making promises that we are not going to fulfill. And I am definitely convinced that you cannot promise victims what you're not going to fulfill. That will victimize them again. So it's important that we have this big discussion involving society, involving Congress, involving the government. And so that's why we provide for particular protection, not only for the plaintiffs, but those who were similarly situated, meaning those that were living in the Bojava River. All of them would have the same protection. But then for a bigger picture of how to address issues of climate change and forced displacement, well, we call on Congress to do that.
Professor, I have 2 more questions for us to wrap it up. The first one, and I think you already answered part of it, talking about the public hearings and the openness of how the decision was crafted. How did the court dealt with scientific evidence? Because when turning to studies of climate change, etc., there will always be those who will argue, is there truly an institutional capacity of the court to deal with such evidence? How did the court dealt with that?
Yeah. So in this case, it was so in this case, we didn't have to deal with the discussions on scientific evidence because this case was very easy. This case, as I mentioned, it was the flooding of a river twice. So the facts of the case were not like this big discussion about scientific evidence. We had that discussion, and as a matter of fact, I have a dissenting opinion in another case that it was about a state of emergency in La Guajira, in which the discussion of scientific evidence was interesting. And my dissenting opinions is what it says is that the court lost a very important opportunity to discuss what we are counting as scientific evidence and what could count as scientific evidence and what cannot count as scientific evidence, taking into account that science is not neutral, that there's also dispute among studies and so forth. In the Guajira case, I was a rapporteur, but I end up dissenting in that. So my proposal was defeated. But in that time, we did public hearing, a very big public hearing, and we invited the rapporteur for climate change. We invited, the renowned scientifics of the climate change panel and experts that are from the academia that are recognized as not basically favoring any party, but just doing their thing. But I think we haven't addressed what science is important for us and what not. I think that's what I put in my dissenting opinion, and I think is a pending question in Colombia and I think elsewhere. If one sees the Inter-American Court opinion on climate change, basically, in the way it explains what is taking into account or not, basically it's signaling that there are not every voice that says they are doing science could be heard or not. There has to be kind of a consensus that is scientific evidence that has at least a broader consensus, that is serious and that is studied and that has a strong methodology or not. But I think you're raising a very, very important question, because in this, as I mentioned, this was not a debate, because the facts were very simple. It was not contested facts. And because we were not only addressing climate change here, and if you see 1, 2, 3 says due to environmental factors. So it was trying to encompass more things than climate change. So for example, flooding or disasters. So that's why it was not a contested issue in our study. It was in the Guajira case, but I think is very, very important. This is an issue that I think we must keep discussing. What count as scientific evidence for the courts? What kind of evidence can the court provide? Do we have to have a standard to see if the evidence that we have been provided has a methodology that is strong enough to have let's say neutral resorts or not? I think those kinds of questions we must be answering. We have had a discussion, for example, in a recent case, and a different one that has to do with something that is called zero rating. And in that case, the dissenters put forward a lot of studies. And we, the majority, are contesting those. We contested those studies as not having a methodology strong enough in order to provide a conclusive decision. And I think in these cases of climate change, well, this is a very big debate. I can hear you. Sorry, I can hear you.
Sorry, we had something close to this during the pandemic when Congress made a study as requested by the Constitution to create a floor remuneration floor for nurses due to the effort in the pandemic. And when they tried to make the legislation work, most of hospitals and private and public hospitals tried to contest the constitutionality of the law that was grounded on the constitutional amendment, saying that the study provided by Congress was not good. And the court had to intervene to assess if the study was good. And I think there's a an Israeli academic, Itai Bar Simantov, that called this semi-procedural judicial review, that it's a mix between material and procedural judicial review that allows courts to assess the rationale of the legislation that is being passed, or something like that. But to my last question, if I may, Professor.
No, but I can add something. It's
Sure.
important in the 1 to 3. Definitely, we have also. So there were a lot of the amicus curia, and there were a lot of intervention, even from the, let's say, state meteorology and environmental institutions, and from other institutions, and the standard for that decision was if there was a reasonable justification, which is a low standard. But in the Guajira case, in my dissenting opinion, what I say is that we definitely don't have, or at least we have not addressed questions that are important. What scientific evidence should be prioritized? How can conflicting conclusions be resolved by a judge? So I think those are kinds of questions that is important for us to address. I put it forward in a dissenting opinion, and I think my court lost a very important opportunity to at least start talking about that. I think that things were really important.
For our last question, we are seeing these extreme events in a very high rate, and they keep increasing. Brazil just experienced a major flood during months in Rio Grande do Sul. So in this scenario, is Colombia Constitutional Court envisioning articulating a particular doctrine, or do you think the current jurisprudence is or the current Colombian jurisprudence is enough to deal with this climate-related and human mobility change and these problems they are rising due to these extreme events?
No, definitely not. So one of the things I want to say is that I'm happy that the 1, 2, 3 has had an impact on the regional level and also in international arena, because that could also help to push for putting in the agenda one issue that for us was really important. But I've been giving a lot of conference so I have a paper that is called Domestic Challenge to Global Problems. These are global problems. These that has particular expressions domestically. So mobility and climate change, forced displacement and climate change is not a thing that only Colombia experiences. As a matter of fact, the data is showing that there are more people nowadays forced to displace and forced to mobilize due to factors associated to disasters and climate change, more than violence and armed conflict, which is already a tragedy. So this is basically a phenomenon that worldwide we are experiencing and we will experience. Definitely, it affects most vulnerable communities. Definitely, it will affect the South more, and vulnerable ecosystems. But it affects the world in its entirety, and this is a global problem. So the question is, what domestic judges what can we do? And there's a big debate nowadays and discussion about the rise of climate change litigation, and so people are asking, well, how is this a good strategy to go to domestic judges in order to address the global problem? And some other people said, no, there has to be a global court or an international court that address those issues that affect the world in its entirety. I insist that we domestic judges have a lot to say still, as for example, illustrating how those global problems manifest in particular places. and this is the case of 1, 2, 3, is how it manifests in particular places and how particular places have the challenge to address these global problems. I also have cautions about global courts in the sense that sometimes when you will have to, then you have a lot of, let's say, diplomacy and negotiation to do, where domestic courts, we are kind of we have more leeway to address the particular issue that we have at hand. And sometimes in international courts and the ones, perhaps those particular manifestation in very vulnerable places are not addressed in the same fashion as we domestic judges can basically respond to them. But the problem is that you can have a lot of domestic courts litigation on climate change. But I think the only thing that this could have a very big impact is that if we all courts row in the same direction. If we don't move in the same direction, what you will have is a lot of cases going from one place to another. So in this particular case,
you mean the use of international paradigms to say, oh, you see the different.
No, so if you have a court that denies that there's climate change, and one court that and one court
did
that
this, I understand.
Yes. Yeah, and if you said so, for if a court think that this is important and another court think that it's not important, that this exists, but another court says it doesn't exist, well, we are not doing anything.
But everything in the domestic level or international level?
No, you're asking what we are doing. I said, so the domestic court address an issue that is brought to its attention by a Colombian plaintiff. But what I'm saying is that this issue, forced displacement and climate change, is not limited to Colombia. It's a global problem. It's a global problem. And in many cases that you address issues of climate change, well, this is something that you can, well, so climate change is a global problem. So our decisions would be limited, definitely limited to what we can do and how we can influence in other actors. And so what I said is domestic judges can help in pushing for topics, pushing for trying to bring other actors into the agenda. But definitely they cannot solve the problem because it's a global problem by themselves. So my reflection is what you were saying, if this was limited to Colombia, it is not. If my decision or if the decision of my court is only limited to Colombia, yes, it is, but it has had an impact elsewhere, and that's something that is important. And I think when we judges in domestic settings address an issue that has a global dimension, I think another responsibility for us is try to bring light for other actors into the phenomenon that we are living, how we are experiencing that phenomenon. And I think that's what the 1, 2, 3 has done. This is a problem of humanity, but it manifests in a particular way in Colombia, and Colombia has some challenges to address this. But what I said is, I think we have to have, as domestic actors, I think a consciousness that our decisions have to row in the same direction. And the same direction, at least for me, is to realize that climate change is a fact. It's not. It is a fact that is affecting people. That is affecting people in the most vulnerable places. That we have to address this issue, like rights on, and that our state, and that we can push our states to basically address those issues ambitiously, not basically with ambitious, because this is happening and this is happening fast. And we really need to resolve that. And so I think as domestic judges, we do have to have, let's say, a cosmopolitan mind, and not simply with respect to these global problems, and not simply addressing the bits and pieces that we have in our case, facts of our case.